Welcome back to the Isn't That Rich podcast. I'm your host, Jill Franks.
And I'm Ashley McVicker.
And today we are talking all about trust. So if you've ever found yourself wondering what happens when someone leaves you a trust, today's episode is for you. Our guest today is Evan Taylor. He's a trusted voice in estate planning and someone many of you might remember from our Legacy Sessions event back in 2023. Evan isn't just a lawyer, he's a strategist and an expert when it comes to navigating the world of estate planning, probate, guardianship, business law, and real estate law. Evan brings a well-rounded approach that ensures your assets, whether personal or business, are protected in the way you actually intend them to be.
In this episode, you'll hear Evan walk through the ins and outs of how trusts are set up, how the distributions really work, what pitfalls to avoid, and the questions you didn't even know to ask. So, if you've been left a trust or you think someone might name you in one someday, this conversation could save your family time, money, and conflict. Let's jump in and welcome back Evan Taylor.
Yeah, thanks for having me back. I guess I should be flattered that I am back. So appreciate being here, and I love your setup. It looks a lot different than it did last time I was here. So yeah, thanks again for having me. I'm looking forward to talking on this topic, and if anybody has more questions for me, they can always set up a consultation. We do free consultations at our law firm, Lawler Brown Law Firm. So happy to answer any questions. It's free of charge. So if there's anything coming out of this that people want to know more about, I would, encourage them to reach out to me.
Yeah, that's awesome. I love that you guys do that free consultation.
Absolutely. I think it makes people feel a lot more comfortable coming in, knowing that they can talk to the attorney, not feel an obligation, get some more information, and take it from there.
Yeah, definitely. We were talking before the show a little bit about how nervous people get when they sit across from an attorney and they're like, oh, am I going to get charged for this? Are you making me sign a contract?
Am I going to have to sign a contract? I think we're going to do something sneaky or something like that. So no, it's completely free, no obligation. So definitely encourage anyone to come talk to me. I think I can, whether they're wanting to create a trust, whether they're the trustee of a trust or the beneficiary of a trust, I can help them, in whatever role they're in. And I think I can take a lot of weight off their shoulders, make things easier for them.
Well, I think this is going to be a really good episode because when Jill and I were kind of planning our questions for you, we're like going back and forth like, no, I think this is what that means. And I think this is what you do. And I think this is how I would receive this type of money. And we're like, we just need to wait.
We just need to talk to Evan.
Absolutely.
Talk to Evan. So I'm excited for the conversation today.
If you try to look it up yourself too, there's a lot of bad information out there. There's a lot of conflicting information. It can be very confusing trying to just, do your own kind of Google research and things like that. Yeah.
So I shouldn't make a trust in ChatGPT by myself, right? I should still go to you.
If you want to do that, make sure your trustee and beneficiaries come to me later because I'm going to need to help them a lot through that process. So yeah.
Awesome. All right, let's get into it. So for those who have never heard of a trust, can you run us through what is a trust? Really?
Sure. Yeah. And I get this question all the time. And there's often a lot of confusion between, a trust and a will, because in a lot of ways, those are documents that sound very similar. You're appointing someone to be the representative. You're deciding how you want to leave things. But with a trust, the main difference between a trust and a will is with a trust, you're creating a legal arrangement, kind of an informal legal entity, almost like a business where you have a 3-part fiduciary arrangement. So you have the grantors, that's who creates the trust. You have the trustees, the person managing the trust, and you have the beneficiaries. So obviously the people that benefit from the trust. And because you have that 3-part legal arrangement, you're creating this entity. And unlike a will, which is just a declaration, we can put assets into this trust. We can run assets through the trust. We can designate the trust as a beneficiary on an account, for an example. Whereas with a will, if you have things passing through that and you need to create the entity, you have to go to court, go through probate. That's where that entity is created. Whereas with a trust, we're creating that entity now to avoid that whole process later. That's one of the main reasons for doing a trust is that probate avoidance. Another is it gives you a lot of great control over distributions. Kind of by way of an example, and I can kind of refer back to this throughout this, my wife and I have a trust. It's a joint revocable trust. So we're both the grantors in that arrangement. We're both the trustees as long as we're alive. And then if something happens to one of us, it's the other. And then we're, during our lives, the beneficiaries. And because we're in all those roles, it's revocable. We can do whatever we want with it. We can change it, update it, any type of amendments, a complete restatement. We can do whatever we want. When we both pass away, we have a 9-year-old and a 13-year-old daughter. They're the beneficiaries. They each get half. But right now, because of their age, we wanted to protect that distribution if something happened to both of us. So the way our trust is set up is if that happened, each of them have a trust within our trust where it can be used for health, education, well-being, but they don't just get outright distributions. At 25, they get half, and at 30, they get the remainder. So that's just kind of an example of how something could be set up. Different people in different stages of life have different goals, but at our stage, having younger kids, that was our goal. We want to keep everything out of court. We wanted to get the right people in charge of the assets, of their care, and we wanted to protect their money and kind of spread it out over time. So hopefully it will be used in a better manner. I know I shouldn't have gotten any money at 18 or 21 or anything like that. So I wanted to protect them as well, kind of from themselves, I guess I would say.
That's so interesting that you have it distributed at different times in their age.
Yes.
Yeah.
I thought really kind of, part coming after, potentially they're through school, that kind of thing. And then part later when they're maybe more established, have a home, that kind of thing.
So if you just had a will, if you just had a will, and you and your wife passed and the girls are still this age, what kind of difference in this scenario that you're giving us, what would that look like, trust versus will with the kids and the distributions? Can you still put things in a will as, hey, you can't get this until you're 25, or is that?
So that's a great question to kind of compare the two. So in theory, I could do the same thing through a will, and I could establish those trusts, those same provisions in a will. I could make it look a lot like my trust. The issue you would have there is if I wanted to do that and establish that trust, I would have to run all my assets through my will. So I wouldn't be able to make in this case, if I have an account, I can make the trust the beneficiary. Something happens to us both, it's all right there in the trust. We can open a trust account, manage everything through that. If I had to run it all through my will, we'd have to go to court. So we'd have to be establishing the trust through court. We'd have to run whichever the last of me or my wife to pass as estate through court. Everything would have to go through that process. We'd have to publish in the paper, do inventories, accountings. It's a very public affair. And then you'd have to establish those trusts through the court. You also often have to get another attorney involved called a guardian ad litem to oversee the case for minor children. We can avoid all that process by using that trust. So you can set it up in a similar manner through a will, but it's a lot more work later on, and it's a lot more headache, and it makes it a lot harder on the people you're putting in charge to have to go through that process rather than just having it already set up in a more informal manner.
Man, the public part is something I think a lot of people would want to avoid.
A lot of people really like their privacy, and so that's a common thing I like to go over in the initial consultation is if privacy is a concern of yours, we need to set up that trust, run everything through that, keep it out of I wouldn't want an inventory of all my assets and everyone knowing everything that's going to whoever I want it to go to, where anyone could go to court and find that out. So privacy for myself and for a lot of people is very important.
Well, I think this is a great point to compare the two because, and this is just my personal opinion about the way I've always thought about trust. It's like something you make later on in life when you're about to retire and you want to make sure everything's set up to pass on to your kids, when really this is a great example of you have young children. You want to protect them. You want to protect their privacy and make sure everything happens exactly how you want it to.
Exactly. It's not just for people that are, in the late stages of life. It's also not necessarily for people that have a lot of assets. I think that's a common misconception. I'm not a millionaire, so I don't need a trust. That's really not true. It has a lot to do with your individual situation, your family situation. Do you have young kids? Later in life, sometimes it can become more of an issue with like a blended family. You want to make sure you're protecting your spouse, but also protecting your children if you each have separate children. So every situation is different, but it's an important consideration no matter what stage of life you're in.
Yeah. So candidates can be not just the wealthy, because I feel like that's a huge misconception. Absolutely. Any assets you have, a trust might be worth it.
And it's not necessarily, for everybody. I don't do a trust for 100% of the people that come to me. but I do it for a majority of people, and a lot of people, given their situation, need a trust. And depending on the situation you're in, it's probably more affordable than what you have in your head, but that can vary greatly as well, depending on the circumstance, the assets, and the situation.
Yeah, definitely. So my next question, you mentioned how your trust is set up. So what is the difference between revocable and irrevocable trusts?
So a revocable trust, kind of going back to my trust, it's a trust where, and sometimes it's just by the terms of the trust, but in my case, my wife and I are the grantor, trustees, and beneficiaries. So since we're in all those roles, we have the freedom to do whatever we want. So a revocable trust is one you can amend, you completely restate it, or you can revoke it, which is where the name comes from. And an irrevocable trust is a trust where you don't have that freedom. You can't be in all of those fiduciary roles. So if my wife and I were setting up an irrevocable trust, someone else would have to be the trustee. There'd have to be some other like lifetime beneficiaries in there as well. We can't be in all those roles. And that's what makes it irrevocable. We don't have the ability to change it. It can't be revoked. I most often do revocable trusts because in most situations, people still want and need that freedom moving forward. But you do use irrevocable trusts in certain situations as well. The most common would be someone that's needing help with getting qualified for Medicaid. Maybe they're worried about their assets being spent down if they have to go into a nursing home, that kind of thing. Or some people, if they're into an estate tax issue where their estate's gotten to a certain value and it's going to be taxed over that value, we can shift some assets into an irrevocable trust to reduce or eliminate that tax burden. So it's less common for me to do irrevocable trusts. I do them, but mostly I do revocable trusts.
That's interesting. So I'm concerned about what would actually be put in a trust. So can you kind of go through examples of things you would recommend putting in a trust?
Absolutely. And that brings up a good point too, because I look at trust planning as really a two-step process, and both of those steps are equally important. But the one most people focus on is the documents themselves, getting the documents in place, how they want them, who's going to get their assets, how is it going to be distributed. But equally important is making sure that trust is properly funded. So what are we putting in that trust? If you do a trust and you don't properly fund it, it's like you've built a house and you never move into it. Like that doesn't make any sense to just leave your house empty. And it's one of the most common mistakes I see. People come to me after someone's passed away. They're like, oh, they had this trust. We get this, that, or the other. And we start talking through it and we realize, well, that never got put into the trust, or that account's actually designated to this person, not to the trust. So it's very important, and it's often an issue in trust planning. So you have to treat both of those phases with equal importance. But as far as that funding, like with real estate, like in my example, we deed the real estate to the trust. So my wife and I still have full control over the real estate. We can do whatever we want. We can sell it. We can buy other real estate and put it in the trust. But when we pass away, that real estate's in the trust, so the trustee can do whatever they need to do with that real estate. And we're also avoiding our real estate having to go through that court probate process. With accounts, it really depends on what type of account it is. If it's something that's like tax qualified, you don't want to shift that over to a trust, because it'd be like you're taking this one-time distribution of the entire amount of that tax qualified account. You'd have to pay income taxes on that for that year. So often we'll just make the trust the beneficiary. So if something happens, it flows into the trust after your death. Some accounts we could move into the trust, but it's all kind of a case-by-case basis. What I'll normally do is I create a spreadsheet and we just go asset by asset and make sure everything's getting funded the way people want it funded. It's also really important for beneficiaries. Like if you find out you're a beneficiary of a trust, you need to know the inventory of that trust. You need to know what type of assets they are, so you know kind of a time frame of, well, there's real estate. Is it going to have to be sold? How long is that going to take? What kind of accounts are some of them tax qualified? Can I stretch out those distributions? So it's important not just for the person setting up the trust to know the whole purpose, the whole goal. The beneficiary needs to know more than just, I get half of this trust. They need to know why it was set up, the trust as a whole, how it's going to be administered, so they can have a better understanding of the process and not get angry or upset for no reason if they think it's taking too long or they don't know what's going on. They need someone to clarify that for them and kind of explain the process.
Okay, because that was so you talked about the tax. What did you mention? Like the accounts, the tax was less. You're talking about retirement accounts, things like that, correct?
Sure. I was referring to like tax qualified accounts, like if you have a 401k that the taxes, you funded that with pre-tax money. So if you were to just move that over to a trust, it would be like you were completely withdrawing that money from that account and putting it into a trust. So it'd be like you were taking this one-time complete distribution. You'd have to pay taxes on that. Yeah. Exactly. And taxes are an important consideration really at all levels of the trust process. When you're setting it up, you need to think about that. For instance, you don't want that distribution, but you need to think about estate taxes. Do I have an estate tax issue? Do I need to create that irrevocable trust to maybe shift some assets to that? From a beneficiary level, you need to be aware of what you're getting and how it may or may not be taxed as well. The trustee needs to be aware of, if I hold income, if I'm administering a trust, like for my girls, as an example, and it's making income, the trust is going to need to pay taxes on that, or we could distribute it to the girls. They could put it on their income tax. We could send them a K-1. Every level, there's considerations with taxes. So it's important to have an attorney involved. It's important to get an accountant involved. You often want a financial advisor involved. There's a lot of fiduciaries and people you need to get involved in this process. It's not something that you should just be, trying to do on your own. There are certain, simple situations where that might work, but oftentimes it's well worth the peace of mind to hire an attorney, regardless of the role you're in a trust.
So we're still kind of on this topic of like what assets should go in the trust. And you've just said so much information. I'm like, whoa, this is like
a lot of information.
This is a lot.
Yeah.
That's why you go to school for so long.
Yes.
So we talked about these like tax accounts or like a 401k, but like your basic checking account, say it has, I don't know, $100,000 in it and you pass away.
Yeah.
Does that money, you're saying you should leave that out of the trust, or that flows into the trust afterwards, or I'm asking 5 different questions.
It's a great question, and it's interesting that you used $100,000 for the example as well. So with general bank accounts, checking accounts, savings accounts, I typically would not have you move that and create like a trust account.
You can keep that in your beneficiaries, name. Right?
Exactly. And so like with my wife's account, they're mine and my wife's accounts, they're still just in our names. They're not in our trust.
Put it in the trust.
But you want to make your POD or TOD or beneficiary designation, whatever that financial entity calls it. If something happens to both of us, it needs to flow into that trust.
Okay.
And the reason it's very important to, if nothing else, have that beneficiary designation is you mentioned $100,000. In Illinois, the 2 main probate triggers are if you pass away with real estate just in your name, that's going to go to probate. Or if you have $100,000 in other assets just in your name, no designated beneficiary, that'll go to probate. So it's even more important in your $100,000 example. That's that threshold. And so, but you're right. We don't, typically the only thing I shift ownership of into a trust, like in my situation, is the real estate. Everything else is just going in designated. Life insurance, bank accounts, financial accounts, investments. It's all just beneficiary designations.
Okay. Gosh, it's just like a really good point, because I have conversations with my friends all the time. Like, do you have beneficiaries on your bank account?
Right.
That's the easiest thing you could do to make sure it goes directly where you want it to go.
Very
at least
simple form. Yeah.
Your money. So.
Yes. Yeah. It's an easy process. Even if you don't have a trust, just getting those beneficiary designations how you want can help a lot if something happens to you, to not tie those assets up in court.
Yeah.
Interesting. Okay. So I just got a call, just setting the stage. I've been left of trust. What is the first thing I should do? Or do you even get a call? That's my thing. If somebody passes away, how do you know
Jill's
about
a trust fund baby.
I wish I was a trust fund. I'm not a trust fund baby. I'm just saying, for example, I got this call.
I thought you really got a call.
Didn't actually get this call.
You like made it sound like you really got
I thought
one.
maybe this was turning into a consultation.
I was, trying to set this.
You need to charge her.
Yeah.
I love it.
Yeah. Well, I mean,
so what happens?
If you get that call, first of all, congratulations, because I think everybody wants to be the beneficiary of a trust. I always hear about these rich uncles that have the trusts or whatnot. But the first thing is, you need to determine, do you have a copy of the trust already? And if not, you need to get one so you can review it, find out what it says, try to find out why it was set up, what you're entitled to. Beyond getting that copy of the trust, you need to find out a timeline on getting an inventory, because beyond knowing what the trust says, you need to know what it has and kind of get a better handle on that timeline. It is the trustee's duty to provide that information to you, provide a copy of the trust to you, provide an inventory to you, to do accountings on at least a yearly basis to you. And depending on the type of trust or how it's set up, it may not even be open for a year once you're the beneficiary of it. But it's really important in that situation. The threshold question is, what do I have and what's the timeline going to be? You should be reaching out to that trustee to find that out. If they have an attorney, you'll most likely get a letter. I send out kind of a almost form letter, just letting them know they're a beneficiary. Here's a copy of the trust. We're working on an inventory. We'll get that to you as soon as we can. Or if we already have it, we could include that too. Any questions, give me a call. Sometimes the trustee doesn't have an attorney, so you're just trying to communicate directly with them. As long as they're being open with information and getting it to you in a timely manner, I wouldn't be too concerned. One of the most common issues I see from a beneficiary standpoint is people allow themselves to be in the dark for too long. And by the time they come to me, I've seen times where it has been years. Sometimes it's been over 10 years, and they really just don't know what's going on. And by the time I get involved then, first of all, it's going to be almost impossible for me to make them happy, because there's going to be all kinds of legal fees just trying to recreate the history, do a forensic accounting, subpoena entities to try to find out, why are we here? Why has nothing happened? Or why has only a little happened? Why is this still being administered? What was the initial inventory? Where is the money gone? And so if you're not getting good feedback, you need to get an attorney to push the issue right away. But I kind of went on a weave there. Back to your original question, need to find out. Copy of the trust is number one. Find out what it says, what you're entitled to, and then inventory is step two. Find out what's in it.
Okay. So are you the one, and you may have just said this, but are you the one, okay, let's say rich Auntie Jill passes and she leaves everything to me or a piece to me, whatever, and you did her trust. Are you the trustee? Or just is someone else in her life the trustee?
So it would be someone else.
She
Typically,
designates.
it's not going to be the attorney.
It's not. Okay.
It's not. So
that's where I think I was confused.
Oftentimes the trustee, so like in my wife and I's case, we have just some individuals we obviously trust. That's why they're the trustees that would handle things for the girls.
That's a great way to remember it, Evan.
Beneficiaries benefit, trustees, you need to trust them. And so, but they would say it's not unusual at all, though the trustee could hire any attorney they want to help them. Normally they are going to go to the person that set up the trust. So the trustee is usually going to come meet with me. They're going to see my name on that trust, make an appointment. I'm going to go through it with them, tell them what their duties are, and then they'll have the option to, hire me or try to do it on their own. If I'm representing the trustee, I couldn't then represent the beneficiary as well. So they need to get another attorney to represent them. And that's something I often have to really clarify as the attorney is like, I need to make it clear I don't represent you as well. I can give you information, but I'm not your attorney. I'm the trustee's attorney, just to not create any type of conflicts of interest or anything like that.
I wouldn't have known that. Like you couldn't.
So many legalities.
Yeah.
Wow.
Yeah.
So the trustee would reach out to me and say, Jill left you her diamond earrings.
Exactly.
Here's the copy of the trust.
Here's a copy of the trust.
And I would get to see the entire trust?
Yes.
Not just the portion that goes to me. You get the full document.
Sometimes they will just give you a portion, but if you insist on getting a full copy of the trust, you should get a full copy of the trust.
Yeah, because you get to see the inventory, and you need to
need to see the full copy of the trust, and then you need some kind of inventory from them as well. And oftentimes the trust document itself will not have that inventory attached or anything like that. It's something the trustee or the trustee's attorney is working to try to find out what accounts are coming into this trust, what was already in it, was the real estate deeded into the trust, that kind of thing, trying to find out what all's in it.
Okay, so you only receive the inventory after that trigger of the death, correct? Or are you, like, as a trustee, are you getting it beforehand so you know how to handle things? Like, say my grandparents are getting of age where things might happen. Are you knowing this stuff ahead of time, or is it often a surprise?
So it's really up to the grantors, the people creating the trust, how much information they give in advance. I would at least recommend making those trustees aware. I've named you the trustee. This is what I set up and why. You may not want to give them a full copy of the trust then, because it may contain information you don't really want them to know now. And it's also something that could change in the future. So, I mean, you don't want to just have to keep giving them copies. With the beneficiaries, it's also a good idea as well to give them a heads up. Hey, I've named you in this trust. This is what you'll get. But a lot of people don't like to do that. Yeah. So it's usually the beneficiaries that are more in the dark than the trustees. The trustees usually at least have an idea that they are a trustee, but they rarely know the assets because a lot of people really keep that private, don't want to share that information. So oftentimes that's the issue with the trustee. When they come to me, they knew they were a trustee. They have a copy of the document. They're like, that's great that I have this document, but I don't know what I'm managing. How do I find that out? And that's when we have to start kind of searching things out. If the trust was through me, we'll at least have that asset spreadsheet from when I gathered all the information. I mean, that's a snapshot in time, but it at least gives us a starting point of, hey, when they met with me, whenever that was, this is what we funded into the trust. This is what was coming into the trust. So we need to start here and then see if anything's changed beyond that.
So understanding this trust, we just got the call, whatever, and we know what to look for as a beneficiary now and all these things. But I have a question here. What does it mean if I'm a residual beneficiary versus an income beneficiary?
Yeah, your status of as a beneficiary can be different depending on the situation. And so that's something very important to know as a beneficiary, as well as what are you entitled to and when. So, one example of a trust I do often in a blended family situation, it'll be a trust similar to mine and my wife's trust. It'll be a joint revocable, marital trust. But if it's later in life, maybe they're a blended family, their own separate kids, their own separate assets. A spouse may say, when I die, this goes into a spousal trust, but then whatever's left from that spousal trust when my spouse passes away then goes to my kids. So you want to provide for your spouse. You just don't want to leave them with nothing. But then you also want to make sure things are going back to your kids. And so in that situation, that trust set up for the spouse would most likely be an income beneficiary. So any income that trust is earning would go to that spouse. They'd also potentially have, some limited access to principal balance of that trust, but then the residuary of that trust. And so the residual beneficiaries would be the kids. So it's going to the spouse while the spouse is still alive. They're an income beneficiary. They have some access to the principal, but then the residual beneficiaries is who's getting everything else when the trust is going to close. So the income beneficiaries getting income often kind of for their life, and then the residual beneficiaries are the everything left over once that spouse passes away.
So the spouse, when you say like this, you're saying a principal, like dollar amount,
yes,
like accounts, so they can't drain that.
That's right. So
I use very blunt language. Like they can't drain it.
It's not going to go and drain the accounts, and then there's no residual.
And that's often a concern, is we want to provide for the spouse, but also make sure there's money left over for the kids. So the trustee will normally have some option to give some amount of principal, or for certain things can access principal and distribute that. Usually the income is just mandatory. Give them all the income. But as far as accessing beyond that to the principal balance in those accounts, there's restrictions of some sort. And then whatever's left over goes to the children. That's also a situation where I can see trustees get into some issues if they're trying to do the trust on their own. It's really good to have a trustee to bounce things off of. Like if a spouse is making requests for money, go to the trustee just to protect yourself and give peace of mind. Is this a situation in this trust where I can do this? I got involved in a trust not long ago where a trust was set up just like that, and it wasn't the spouse that was an issue at all. The trustee didn't understand the difference between the income beneficiary and the residual beneficiaries. This trustee saw these kids on here and was like, well, I can give them money too. So as I looked into the accountings of the trust, I saw all these distributions to the kids from the spouse's trust. And I'm like, well, why is that happening? And they just did not understand that it was the spouse was the beneficiary now for income, principal, and then it was the kids. And they'd been making all kinds of distributions from the spouse's trust to the children. Fortunately, and what is often not the case with a blended family, everyone got along. It wasn't a big deal, but it could have been a big deal for the trustee if these were parties that didn't get along, wanted to force an issue, make an issue out of it. It wasn't in that case, but it's a great example of why trustees should really, especially in a case like that, have an attorney.
Yeah, that was because are the trustees liable for that, or how does that work?
Yeah.
You know what I mean? If you're responsible for this and it's being distributed incorrectly.
Yeah, the trustee has a fiduciary role, and so they're a fiduciary just like an executor under a will is a fiduciary, an agent under a power of attorney is a fiduciary, a guardianship or a guardian and a guardianship's a fiduciary. So they have a duty to uphold the terms of that trust. They have a duty to prudently invest the assets of the trust. So their duties, to those beneficiaries to uphold those terms, to prudently invest. And if they violate those duties, they can have liabilities.
I see.
Gosh.
Yeah.
No.
So in this situation, why wouldn't somebody set up, because this sounds a little hairy, like what you're saying, like it could get crazy. Why wouldn't a spouse in a blended family set it up to where when they pass, the spouse, and maybe they can do this, I'm sure there's just lots of different options the way you're talking today, but they get whatever, and then upon death, the kids get their whatever.
Yeah, so a blended families,
I don't know.
If you're in that scenario, estate planning is more important than in any other situation, because if there's going to be fights, that's the most common scenario. When you have, a spouse later in life, you each have your assets, you each have your own kids. And so you can set it up however you want. Mm-hmm. And in a marital trust, you can even kind of compartmentalize assets where it says, what we're putting in this schedule is marital assets. So if something happens to one of us, it just goes to the other. These assets are what I brought into the marriage. These assets are what you brought into the marriage. And within that framework, you could give certain assets to the spouse just free and clear if you wanted to. Do whatever. It doesn't have to be that income kind of residual beneficiary scenario. Or you can say, these assets go to the spouse, these go to my kids outright. There's really no limit to how you can do that. And when you have that kind of income spousal trust, that's typically when you have a spouse that brought way more into the marriage than another one. And so they're wanting to make sure that spouse is taken care of because they may not have much, but then also they don't want all their assets to go to their spouse. They want to make sure their kids are being provided for as well. And in that situation, they probably wouldn't be putting everything into that spousal trust. Their kids would already be getting something when they passed away. They're just setting aside some money for the spouse too, for their care. And then whatever's left over would then go back to their kids as well.
Okay.
That's so good. So how long does this whole process take? And I know it varies, but so you get this trust, how long does it take to distribute the assets? Or is there like a requirement? I mean,
could you said 10 years one time that nothing happened. So,
or can like you have a bunch of real estate and it just continues on, or does it have to, upon death be executed, I guess? I don't know.
It really does depend and vary a lot on the situation, because the terms of the trust and the assets in the trust can really dictate that time frame. But if it's the trustee also is working within that fiduciary framework, so they have a duty to be administering this trust, to be working towards whatever the goals of that trust are. There's no set deadline, like you must distribute within, X amount of months or anything. In my example with my daughters, if something happened to my wife and I now, that trust is going to be administered for a long time because they're 9 and 13, but it goes till they're 30. So that time frame is going to be a very long time frame where it's having to be administered, distributed for certain things, half at 25, half at 30. But hopefully my daughters are over 30 when something happens to my wife and I. And so in that case, it'll be a much easier administration. All we're trying to do is essentially just settle the trust. So we're getting all the assets in one place. We're making sure they're all funneled into that trust. We're paying any last debts, and then it's just going to my daughters outright 50-50. That should only take a matter of a few months. That should be a very short time frame in that situation. But if they're under that age of 30, it's a very long time frame. So it can depend, on the trust, the framework of the trust, how old the beneficiaries are. There's a lot of variables there. But if you have any confusion on that at all, the trustee should be keeping you informed of what's going on and what the time frame is.
Got it.
Wow, so many questions I have.
I know.
This is something that Jill and I were talking about the other day, just how things get distributed, and maybe we can just focus on real estate.
Yeah.
Let's say a trust had 2 properties in it. One goes to one kid, one goes to the other. I mean, can you just explain that scenario, like how that works? Is it just immediately like the title gets transferred out of the trust, that comes out of the trust, and then the trust is like gone?
Yeah.
Yes.
Does that make sense?
Yeah.
Is that?
And maybe you can reword my question to a better scenario.
You're probably tired of me saying it depends, but it really does. So with real estate, again, with my trust, our house would be in it. And so my trust, though, doesn't dictate anything specific about our house. It doesn't say the trustee must keep it and let the girls live in there, or the trustee must sell it or must keep it for this amount of time, or must try to rent it out and give the income to the girls, or anything like that. So in that situation, the trustee's just got to figure out what is best in this scenario. Do I need to keep it so the guardian can live with the kids at the house? Is that best for them? Do I need to sell it and invest that money for them? Is it a good rental property? Do I need to rent it and have that money come into the trust? So it's completely up to them, but the terms could vary. If someone's got a bunch of rental properties, they may direct, hey, we want to keep those in trust, keep renting them and manage them for the kids. Or they may say, no, liquidate it all and put those in trust for the children and invest that money. So it's really varies situation to situation, trust term to trust term. But the great thing, and also kind of sometimes for people, the difficult thing about trust is the possibilities are almost endless. I mean, you can dictate a lot of different terms. You can set things up a lot of different ways. It can be difficult then for people to decide exactly what do I want to do. I normally encourage people to give the trustee discretion to leave things somewhat broad, because if you really start trying to dead hand and dictate things in a very specific manner, the future is always not going to be exactly what you think it's going to be. And it can cause a lot of unintended consequences, a lot of headache later on. So I always kind of lean towards keeping it more broad, giving that trustee discretion. You're putting them in charge for a reason. And so if you don't trust them enough to make the right decision, you need to consider someone else.
You could always put in a trust what not to do with the property too, right?
So
like instead of saying like I want you to do this, that, these, and those, you could just say, please just don't, if anything, don't give it to Cousin Bob.
Yeah, and
whatever.
You can do terms on what you don't want to have happen to certain assets, what you do want to have happen to certain assets. You can disinherit people like Cousin Bob in that scenario.
Okay.
So yes, absolutely. Yeah. And one thing important to consider with distributions is people really get hung up in that front line, like, my daughter's 50-50. It's also, even though it's something you don't want to think about, what if something's happened to one of them? What if I pass away with one of them in an accident? What happens to their share then? Or what if I've passed away, we're administering their trust to 30, something happens while we're administering that trust for them? So distributions are something important to talk through with an attorney, because you don't want to just think about that front line. You want to think about all the scenarios. What if something's happened to them? They've passed away. What if they become incapacitated? We want to protect their share for them, not just have it go to, the state or something like that. So there's a lot of considerations. Distributions are a lot more to talk through than I think a lot of people, when they initially come to me, think of. They've always thought about that front line of course I want my kids to get it. But when you really start talking through, what if this happens, this happens, this happens, it becomes a whole nother conversation.
Yeah, it goes a lot further down the family tree, doesn't it, than just with who initially.
It's a lot deeper, and it's very important because it happens.
Yeah.
Where I'll come across a trust or a will that someone brings to me, and it's like, well, they left it to this person. Well, what's happened to them? Well, they're gone. It's like, well, this doesn't say what to do then, so we have to just go by Illinois law. And then they tell me, well, there's no way they would have wanted that person to have it. I'm like, well, I can't do anything about that now. So it's very important to think through all those different kind of scenarios and contingencies.
Important to use your attorney for that.
Absolutely. Yeah.
And I'm thinking about like the trustee, this person that's designated to basically run the show.
Yeah.
I think I have two questions. Is the trustee paid at all? Or are they just like, because it seems like,
you know what I mean? It's a job.
You're talking about this trust like it's a business entity kind of. And so then there's kind of the trustee is like the business manager. Well, do they kind of get a little kickback, or are they hoping that the trustee is someone that maybe gets a little bit from the trust? Or sometimes I'm sure there's situations where, well, you don't get anything, but now you're in charge of managing my children, my trust, my real estate, all of these things.
Yeah, it can be a lot to take on, and it is often a very thankless job where you're managing all this, you have all this stress, and everyone else is just standing around going, where's my money?
Yeah. Putting their hands out.
Yeah, it's like, and what do they do if they're like, I really don't want to do this?
Yeah.
And so as an initial matter, a trustee does not have to do it. So that's an important thing to consider. You want to make sure you're putting someone in charge that is going to do it, and you've talked to them about it, and you've run them through the scenario, and it's another good reason to try to kind of keep things simple and keep things broad to take some of that burden off that trustee as well. As far as compensation, you could lay that out specifically in the trust. I've seen people do like a specific extra distribution, like $5,000 to this person because they're going to be taking this on. You could alter percentages of what people are getting if you wanted to give them a little extra. You don't see that as often, but a trustee is entitled to just a great legal term, reasonable compensation. And so that leaves it open to interpretation, where the trustee, what I often advise them to do is track all your time. Anytime you spend on this, track it. When we get to the end, I want to look at how much time you spent on it and what you've done, and we'll come up with a figure, usually maybe based on an hourly rate, depending on kind of the degree of difficulty of what they've had to do. Some trustees say, I don't want a dime. This person wanted me to do this. I want to do it for them. Sometimes the trustee is just, like one of the kids, there's two kids, and they're just kind of getting it all together and distributing. They're like, I'm getting half, my sister's getting half. I don't need compensation. But then you have some people that are really having to manage a trust for years. They should absolutely be compensated. And I encourage them to track things, meet with me. We'll put, if it's going on for years, we'll put what we want or what we're distributing in the accounting. If the beneficiaries want to try to object, they can, but oftentimes they're not going to, because they understand what that person's going through.
Yeah. Mm-hmm. Things can get complicated. I think.
It can. Yeah.
Man, lots to consider. This is a reason why I've heard people want to do a trust, is a lot of the tax implications when you inherit things. And so I wanted to talk a little bit about some of the tax conversations that people have. Like, will I have to pay money have to pay taxes on the money I receive from the trust, all that kind of stuff. You mentioned it a little bit, but I think I just hit on it briefly earlier when I was talking about all the different tax implications at different stages and different considerations. And it is really important. This kind of goes back to a beneficiary, not just understanding their section of the trust. Oh, I get half. Great. When do I get it? Understanding the whole process. First, an initial matter, why was this set up? Was there an estate tax issue? Are we trying to reduce or avoid estate taxes? Then you'll know, well, the trustee is going to have to be filing an estate tax return. That's going to take some time. That's going to impact how much I'm getting, because the government's getting some of it off the top. It's also important to understand, they're getting more money even on your money when you die after you've paid taxes your whole life. Exactly. And then, so it's also important as a beneficiary to know, if this trust is being administered, if it's earning income, is the trustee going to pay that tax through the trust, or are they going to distribute that income to me? Am I going to be getting a K-1 and having to report that on my tax return? So that's a conversation you need to be having with the trustee as well. If you're getting like qualified accounts that the taxes haven't been paid on, you need to have a conversation with trustee, financial advisor. Can I stretch these out over time? Can I take distributions over time? So I'm not just getting this one huge tax hit this year. Can I stretch that out over time? So taxes can cause a lot of confusion, can cause a lot of issues, and that stretches out to every role in the trust. The person setting it up, the person managing it, the person getting money from it. They all need to be thinking about, how is this going to impact taxes? How are we going to structure this related to taxes? And so it's important all around with the tax issues. Yeah.
Talking about that, in my $100,000
scenario,
just, an account outside of the trust, you're listed as the beneficiary, you get the benefit of it. It's $100,000, or maybe I'll just use $99,000 to stay away from that $100,000
threshold.
Okay. Do I have to pay tax on that $99,000? Is that considered like an income to me?
I see your question. That's a great question. So from a beneficiary standpoint, the only taxes you would be paying is if the trust had investments or money where it was gaining income and that got distributed to you without the trust paying that income tax, you would pay that tax. Okay. Or if it's a qualified account that the taxes haven't been paid on, you'd have to pay those taxes when you make that distribution. If it's just a general checking account, savings account, non-qualified investment account, you've just done some stock investing, you could inherit that and you do not pay taxes on that. That's not income to you. There's no inheritance tax on that, at least in this state.
Okay.
Some states may have certain inheritance tax rules, but we're not one of them. Illinois only has the estate tax where they look at the estate's value and potentially tax that before it's distributed.
Okay.
No inheritance tax here.
Got
Good
it. So
to
I have
know.
a bank account. I have a beneficiary on it. They're not paying taxes when they take over that.
That's
account.
correct.
Okay.
Yes.
Good.
Yeah.
That's great.
The one time you don't get taxed on
It's
something.
scary because that's another thing is like, oh, I
Yeah.
don't want to put that in my name yet because I don't want to pay taxes on that. It's not considered income.
Right.
Yeah, correct.
But that makes me understand now the 401k, how you paid pre-tax money into it.
Yeah.
You know, tax man's got to hit you at some point. So
Exactly.
if you're taking a distribution from that or that, whatever you're saying, lump sum of it, well,
Yeah. Taxes haven't been paid and the government's going to get it eventually.
They're coming
And
after me, Evan.
That's why those qualified versus non-qualified accounts, it's
Right.
important to make that distinction and determine what you're going to do.
gotcha. Okay, cool.
So I want to talk about some mistakes people make because I feel like it's easy to make a mistake. And what are some of the biggest mistakes beneficiaries make after being left a trust?
The biggest mistakes a beneficiary makes is at the initial outset, not really understanding the whole process, and they'll often start causing an issue with the trustee without really understanding why things are taking longer than they think it should and things like that. You need to understand it as a whole, and so you can better work with the trustee and essentially give the trustee grace if you think it's taking too long. I've seen people just start getting into arguments, having issues between them when it was completely unnecessary. It was just based on a misunderstanding of how the trust was even to be administered. On the other side of that as a beneficiary, though, is just not doing anything about issues soon enough, like talking about keeping things in the dark, where I've had people come years later. It becomes almost a no-win situation for me as an attorney when people come to me years later, because it takes so much time, money, and effort to recreate the history, to do a forensic accounting. That is so difficult to do that from my client's standpoint, they're going to be upset with me at how much it's costing. Why is it taking so much time? Why is it costing so much? And on the flip side of that, if the money's gone, we may be trying to collect against somebody we can't even collect against. And so you cannot wait. If you think, a trustee's doing something wrong or a trustee's keeping you in the dark too long, you need to get an attorney sooner rather than later. The longer you wait, the worse it is. As time passes, it just becomes more difficult. So those are the common mistakes from a beneficiary standpoint. It kind of goes to the same with a trustee, talking about that trust earlier where they were distributing things to the kids, not understanding that they weren't even a beneficiary yet. Just, you have to understand the documents, the funding, and the plan as a whole.
So I guess after the fact, after people die and they leave the trust, and maybe, there's a difference between the revocable and irrevocable, but can a trust be challenged or overturned?
Yes.
Or-
It's very rare for the trust to be challenged or overturned just from the document standpoint. The only ways you would typically see anyone try to do that would be based upon lack of capacity of the grantor, the person creating it. They weren't in their right mind. They had dementia, Alzheimer's. They didn't know what they were doing, that kind of thing. Or duress. Someone was, unduly influencing them, forcing them to do it, coercing them to do it. So you can potentially challenge trusts in that regard. I guess you could potentially challenge it through like a forgery, though I've never actually seen that scenario play out. So there are ways to challenge the trust. The only other ways would be if there was some kind of ambiguity, some kind of drafting issue. That's not so much as a challenge as needing to get clarification, maybe from a court. We think it says this, we think it says that. One very important thing to consider if you're a beneficiary and you're thinking about challenging a trust, and it's definitely important to run this by an attorney too. My trusts and most wills will have a no contest clause that says if you try to contest this trust, all of these can be worded differently, but they usually are some version of, if you contest this trust, you're treated like you died before me and you and your heirs get nothing. So you're all just cut out. It's like you're disinherited. And, if you're not getting anything out of the trust and you want to challenge it, then maybe go ahead. I mean, you're just not, you're trying to get something when you're getting nothing. But if you are a beneficiary of that trust, maybe you just don't like how much you're getting. I have to have that conversation with them. And often I want to put this in writing so it's not an issue for me later on. Hey, if we can test this trust, you are potentially going to lose your $100,000 or whatever. So if that's worth that risk to you, let's go. But it's often very hard to contest a trust anyways, to try to prove if it's been done through an attorney and you're trying to say they lack capacity, they're being, unduly influenced. All attorneys have procedures in place and are meeting with people on multiple occasions to where if they had any question about their capacity, it would most likely come up somewhere in that process, or if someone was unduly influencing, I'm kicking people out of these meetings if I have it. And really, as a matter of habit, at the signing, I'm not letting anyone in that meeting except the person signing. But even if I have any other concerns during the process, I'm kicking those people out of the meetings and only talking to, the client in that situation. So a trust can be contested. It's very difficult, and you better be very careful if there's a no contest clause.
Sounds like we need to put this bit at the beginning of the episode to make sure everybody knows not to do that.
Yeah, right.
Gosh, that does sound like the most important thing. Like if you were going to get $1 million and then you were like still so like mad about something and then you're out. That's crazy.
That could be a really rude awakening for somebody. Yeah.
Well, have you ever had a situation where a trust, this is something I think about, do trusts just, what happens if they run out of money, or does that happen, or run out of the assets and then there's nothing left in it?
At some point, every trust is going to run out of money depending on what the distribution guidelines are. In my scenario, when the girls turn 30, everything's going to be distributed to them. The trust is going to be out of money. And once it has no more funding, it dissolves at that point. If they're over 30, same scenario, something happens to us, it gets distributed to them. There's no more money. It dissolves. Some trusts, if it's paying out over time, it won't say when it's completely out of money dissolves. It'll say when it gets to a certain amount, go ahead and distribute the remainder and dissolve it. Like if there's $20,000 left, just so you're not continuing to have this trustee have to manage this trust when there's only like $10,000, $5,000 left. There's usually some kind of triggering condition that says if we get to this amount, distribute the rest, and the trust is, once it's out of funding, it's over at that point.
Trust is dissolved.
That's
the phrase I've been looking for this entire episode. Yes. I'm like, when the trust is gone over, I don't know,
it's
finished. You've been holding out on me with the dissolved.
Yeah.
Okay.
Because that was another question I had. So real estate, and there might be loans on the real estate. That's we were talking about this.
If a piece of property has a loan attached to it, it's obviously not fully paid for. You don't fully own it, I guess. Can that be put into a trust?
It can be put into a trust, but that obligation still goes with it, and that obligation runs with the land. I've never seen it be an issue if you're funding a revocable trust, putting a piece of property with a lien on it into a trust. I've never seen a financial entity have any issue with that, because that revocable trust is a pass-through entity. The person still has all the control over it. If somebody's doing that with an irrevocable trust, I would always advise them to check with the whatever financial entity holds that loan, just to make sure it's not going to trigger any type of acceleration clause or anything like that.
That makes sense.
Okay.
Yeah, we were talking about that.
I'm not going to talk anymore because I could have like 5 million more questions, but the answer is kind of. He's like, it's kind of yes.
No, I love it.
Yeah.
It's kind of yes.
You can definitely fund any trust with property that has a lien on it. It's just not going to extinguish that lien. It's going to run with the land. You're still going to, if you pass away, your property's still got that loan on it. That trustee's going to have to deal with that. Either keep paying that mortgage, sell it, pay it off. Something. It's going to have to be addressed in some manner.
Got it.
Okay. Got it.
Some questions that people don't think of. Can I close a trust before I get everything out of it? Or that's a question that, I don't know, we came up with.
If that trust is still holding assets, it can't be closed. Okay. From a beneficiary standpoint, that wouldn't be your determination anyways. It would be completely on the trustee as to when that trust is going to be dissolved and their duties are going to be over. But if there's still assets to manage, the only way to close it is to distribute all the remaining assets and then close it. You can't just have it keep holding assets.
I think I kind of mentioned this but this is just a different way to ask the question, and maybe it does mean something different, but can a trust be updated or changed after the person dies?
No. There could potentially be some limited circumstances if there was some kind of ambiguity or a drafting issue, something like that. But again, like with my trust, if my wife and I can amend it, change it any time. If something happens to one of us, the terms dictate that the survivor can amend it, change it at any time. When the last of us passes away, our revocable trust becomes irrevocable at that point. So it locks, and the girls can't say, well, we don't like what mom and dad did. We want to do this, or we don't, like what the trustee's doing. We want to change the terms of the trust. You can't change it at that point. It's set.
So you have yours set to where when you guys pass it, changes to irrevocable.
That's right.
Okay. Is that every trust?
Revocable trust, when the last grantor passes away, will be irrevocable.
Oh,
at that
okay.
point.
Okay.
Yeah, it'll lock at that point.
This made me think of a question too. Is so the trust is set. The people who created the trust have passed, and the trustee, there's other assets outside that aren't. Can they add those into the trust after they're passed, or no?
So if I'm understanding correctly, so you're talking about a trustee, and there's assets not funded into that trust. Can they then be put into the trust?
Right.
So it will completely depend on the structure of that asset. If it has a beneficiary designation, it's going to go to whatever that designation is. Of course, if it's a trust, then yes, it's going to go into the trust. If there's assets being held out of the trust that or just in that person that passed away's name that don't have any type of designated beneficiary, so they're just assets holding out there, that would then depend on that person's will, where that goes. And so when I do a trust, I always do a pour over will, which is just a very simple will that leaves that person's probate estate or estate to the trust. So if there's any assets hanging out there that didn't get funded that are going to pass through an estate, pass through a will, our will just leaves them to the trust, so everything ends up in the trust one way or the other. But hopefully you're not having to utilize that. But it's not unusual to find out, well, they forgot about this IRA they had at this job they worked at 20 years ago or something like that. It happens, absolutely. And so in that case, my will would catch that and put it into the trust.
I see.
You're a good lawyer, Evan.
Yes.
He's got it all wrapped up. He's got it.
It's taken years.
He's got it. Cool.
I love it.
Well, gosh, I feel like we've learned so much today. What's your final piece of advice for all people dealing with trusts and estates and all that stuff?
My advice, whether you're someone wanting to set up a trust, someone that's in charge of a trust, or someone that's a beneficiary of a trust, if nothing else, go have a consultation with an attorney so they can at least talk you through it, let you know what your role is, what you should expect. And then you can decide if you need to hire them beyond that. So get some advice. Beyond an attorney, you're probably, depending on the situation, going to want to be talking to a financial advisor, get some advice on what to do with these assets you're inheriting. And you're also going to be wanting to talk to an accountant. How is this going to impact my taxes? How's it going to impact my taxes? Because we're all kind of in different roles here. The attorney's really good at the legal aspect. The accountant's good at the tax aspect. The financial advisor's good at the investing aspect. You really want to utilize all those professionals. They exist for a reason, and you need to at least be talking to them, having some conversations.
Yeah. And probably talking to your family too, or whoever you want to manage your trust. The person you trust is your trustee.
The person you trust is your trustee. It's also a good idea, a beneficiary. It's a good idea and a good time for them to think, what do I have in place? I'm getting this money. They set up this trust for me to protect me, to make things easy for me, for the trustee. What have I done? Do I need to start thinking about setting something up? So if you're a beneficiary and you don't have your own planning, it's a fantastic time to do your own, because you're probably talking to an attorney anyways that is familiar with this area of law. So why not talk to them about what should I be doing? Yeah, what should I be setting up?
Good. Man, I've learned so much today.
Well, I'm glad.
Yeah.
It's a lot of information to try to do in a short amount of time. So I hope it's made sense and been clear to some degree. But if there are any other questions, people can always reach out to me, schedule meetings, and learn more.
Makes me want to go set up a trust. I'll delete my ChatGPT one and I'll just
you'll
come to you. No, I'm just kidding. I don't really have one of those.
Your ChatGPT trust and then come see me. Yeah.
Well, thank you so much for being on today.
It's been great being back.
It.
I appreciate you having me. Yeah, thanks.
Well, thanks for listening. We'll see you next time.
So, Jill, where do we go from here?
Be sure to check out our show notes for this episode, and also be sure to follow us on social media and subscribe to our newsletter. We'll see you next week.
See you next week.